So we need to talk about a recent 9-0 unanimous decision issued by the Supreme Court, and this involves the Fourth Amendment's protections against unconstitutional seizures and when excessive force by law enforcement officers actually impacts your rights. This impacts everybody because of this new ruling. So let's break down what happened in this critical decision. Now, real quick, if you're watching this channel, then obviously it's safe to say that you care about the Second Amendment and your rights. Now, here's the thing, even law-abiding gun owners are ending up in jail because they make a bunch of critical mistakes. And those are mistakes that you don't even realize that you're making or that you don't understand that they're illegal. So I put together a free resource called the Legal Survival Guide. It's aimed to help you guys avoid all of those traps that maybe you could fall in. It takes about 2 minutes to read. It's just a simple PDF, and it really could save you years behind bars. I made it to help you guys, again, completely free to download using the link down below. It's just something that I wanted to provide to you guys for free so that you can have it in your phone or maybe print it out. And there's a little card also in there that you can put in your wallet to give you additional resources to help you in situations. Obviously, not meant to be legal advice. I'm not your attorney. This isn't an attorney-client relationship, but I wanted to provide you guys some free resources to prevent you falling in some bad situations. Again, if you're interested, click the links down below. It's completely free to do. All you have to do is enter your email to get that free PDF. As I mentioned in the intro, in this video, we're going to be discussing a new and recent 9-0 unanimous decision issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force actually impact that right. That new ruling came in a case called Barnes versus Felix. Again, it was 9-0 unanimous in favor of the plaintiff here against the law enforcement officer. This new lawsuit should be on everybody's mind because it involves how courts must now analyze situations like this one going forward. Although this case is not a traditional warrantless search and seizure case, the Barnes challenge here directly addresses the seizure doctrine and now also how use of force should be assessed under the Fourth Amendment and when things like excessive force implicate that right. As gun owners, we have seen a lot of highly publicized situations where law enforcement officers interact with lawful gun owners and through excessive force, or the gun owner just simply does not know that this person's a law enforcement officer, or they break down their door during a raid or something like that. That individual acts in self-defense, not knowing what's going on, and sometimes someone is fatally wounded. This analysis by the Supreme Court directly impacts those types of situations and involves your rights in those types of very scary and concerning situations. Now, the facts around this case are as follows. Essentially, a police officer, Roberto Felix, ended up pulling over an individual, Ashton Barnes, for suspected toll violations. Those toll violations, I believe, were picked up by a camera, and then the police officer responded and pulled over this individual because of those toll violations. Felix ordered Barnes to exit his vehicle, and Barnes essentially opened his door, acted like he was about to exit the vehicle, but then attempted to drive away. Now, reacting in a split second, the officer there decided to jump onto the ledge of the moving vehicle, jumped onto the open door kind of floorboard of the vehicle, and was on it as it was driving away. He then responded by firing 2 shots at Ashton Barnes as the car was driving away. Mr. Barnes was able to essentially stop the car, but he was fatally wounded because of those 2 gunshots. And this all kind of happened within 5 seconds where, the door was opened. He was acting like he was going to exit the vehicle. It started to pull away. The officer jumped on the vehicle, fired 2 shots, and then all within 5 seconds, the vehicle stopped. And unfortunately, Mr. Barnes passed away. Now, in response to this situation, Barnes's mother and father sued Officer Felix on behalf of Mr. Barnes, and they alleged that Officer Felix violated Mr. Barnes' Fourth Amendment right against excessive force, again because this all resulted out of a toll violation. The District Court on review granted summary judgment to the police officer, and they applied the Fifth Circuit's moment of threat rule. This was then elevated to the Fifth Circuit, and the Fifth Circuit upheld that ruling, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. And under that rule, events leading up to the shooting are not relevant, so they could not be considered in this situation and potentially other cases as well. Here, the precise moment of threat was the 2 seconds where the officer there was clinging to the moving vehicle, clinging to that car as Barnes attempted to escape. And because Officer Felix could then have reasonably believed that his life was in danger, the Fifth Circuit panel held that the shooting was lawful and that nothing was done wrong. This case eventually made its way to the United States Supreme Court, and the question that the Supreme Court decided to answer in this specific challenge is whether courts should apply the moment of threat doctrine or something else when evaluating these types of Fourth Amendment claims. Now, on review, a 9-0 unanimous Supreme Court held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of the police officer requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to that incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis that was used by the lower courts, the Fifth Circuit and the District Court, and instead applied something known as the totality of circumstances to look at the entire situation. They said that you cannot just look at this in an isolated kind of 5-second span. You need to look at everything leading up to the interaction and things that also happened during. So the main thrust of the ruling was rejecting the more limited scope of analysis applied by the moment of threat rule. Instead, the Supreme Court orders lower courts to look at the totality of the circumstances before, during, and potentially even after the situation happens. Now, there were some concurrences also authored by other judges like Kavanaugh, who was joined by Thomas, Barrett, and Alito. The concurring opinion really focused on pointing out how, essentially dangerous these traffic stops are for police officers, how, they lead to a lot of fatalities for police officers. So they did not want to overlook that. And, they wanted to recognize how serious these situations are for police officers when they have to pull someone over. It's really dangerous for them. But they stated that does not mean that you just give them broad immunity and don't look at the totality of the circumstances. They also pointed out how when a driver pulls away like Barnes did, the officer really had no great options. And, that was directly also compounded by the fact that he decided to jump on the vehicle. But they also wanted to acknowledge that the actions of the individual here also pretty much put the police officer in a bad situation, but maybe the police officer made it worse for himself by jumping on the vehicle. Now, during the oral arguments, the Supreme Court was concerned about cases like police officers failing to identify themselves and someone deciding in response to that, exercising their Second Amendment rights of self-defense. They said that limiting those type of cases and reviews to a moment of threat analysis overrides other fundamental rights like your right to self-defense and the Second Amendment, because you're not looking at what the police officer did by not, acknowledging or announcing that they're a police officer, or someone just barging into your house with, no knock or anything like that, no warrant. There are situations where an individual is put in a really bad situation where they respond in self-defense because an officer acts incorrectly. They do something wrong that puts you at risk. Now, they did not directly rule on that issue, but it was something that was raised. It was brought up in this case down below and was also argued in the Supreme Court during oral arguments. And so that was something that the Supreme Court was concerned about. The Supreme Court, because of this, just issued their mandate, sending the case back down to the lower courts. This does not mean that the Fifth Circuit or the District Court here were fined in favor of Mr. Barnes, and they may still find that, he acted incorrectly, but they will need to look at the relevant information before, during, and after the incident potentially, and make the correct decision based on the totality of the situation. Now, one wrinkle to all of this is this case is now being opened up in the lower court, and it's being argued still by the mother, I believe, and also the father of Barnes. And I believe the father is pro se. And my understanding based on some of the filings is that the father is currently in prison. And so he's filing some of these papers pro se from prison. And he's asking for the District Court to reopen the litigation in light of the Supreme Court ruling. But right now, I believe this is actually in the hands of the Fifth Circuit, but there's a ton of filings that are going on right now. And right now, they're also trying to bring in other defendants beyond just the police officer. Now they're trying to bring in other defendants. I believe the DOJ, who has brought notice of this case and decided to not take action against the police officer. I believe also some of the local mayor and some other politicians in the area, and then just other individuals within the police department who were made aware of the situation, were made aware of this case, and did not take any action. So there are more defendants being brought in now in light of what the Supreme Court said. So this is a critical decision that is now heading back to the Fifth Circuit and is now going to be redecided in light of what the Supreme Court said in this case, looking at the totality of the circumstances. And it's going to be interesting to see now how these courts address this case, address this issue, and respond to excessive force, and maybe even rule against the police officer because he acted incorrectly. So this is a critical decision that I wanted to bring to your attention. I think it's something that everyone should know about. As this develops, as we get more information on this case, I will let you guys know. If you want to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armedscholar.com. Over there, we have things like the free legal guide that you can sign up for. All you have to do is put in your email, and we email you over a free PDF. We do follow-up emails as well with additional educational information, some daily deals and coupons and things like that to save you some money. So as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.